Depends.
Wow, okay.
It depends. Mhm. Any more questions, Deandra?
No, ma'am.
I have a question about this exam.
Oh, look what she go. We,
Listen.
you heard her? Did you hear her?
Yes, ma'am.
Oh, she can hear you well now. Okay. What happened?
Like, we have to know these cases and stuff like that.
Yes, ma'am.
No, hold on, I didn't hear the question.
Come and sit up here. Close to
I was
what?
asking if we have to know the cases.
Yes,
Oh,
it's a trust law class. You don't have to know all of them.
You will tell us which ones you need to know.
I will tell, yeah.
Okay.
When I do the review,
Uh-huh.
when I come to do the review, yeah, I'll tell you. Did you remember?
nah, Miss Archer, you know
Yeah.
the review is only a week before the exam.
Yes, and
So, what?
you're supposed to be reading this as you go.
I know, but seeing that we'll be getting specific details, can you consider like maybe 2 weeks before the exam, like even if you email us? Because I know you won't be presenting that 2 weeks before. Good morning.
Oh, I see what you mean.
Like just so we have
You'll have
at
to send me,
least
you'll have to send me a reminder so I can send you
Okay.
lists of the cases.
Okay.
I don't have my email address.
I have one last week's email yet.
You didn't get that yet? Okay, hold on 1 second, Deandra.
Okay.
Tell me if I have it wrong. How come you're not getting it? Let me find out. And now you need one, because she was in the class last week.
I'm sorry.
Yeah, so hold on 1 second. Here.
This last one, yeah. No, it's not. Well, boy.
All right, copying it now. All right, so let's go to unit 3. Nathaniel is there.
Okay.
He's in the office. For him. All right, so unit 3, I asked you all to read it. Remember? Right there, sit right there. So let's go to unit 3. Any questions? Start with you, Deandra, first.
So, Ms. Archer, honestly, I haven't finished reading chapter 3. I am on chapter 3, but so far I don't have any questions.
Okay, and how far are you?
I am on page 30.
Yeah,
She knows why she's not here, you know.
be honest.
No, it's good to be honest, but trust me, I know she's gonna be down to that cultural thing down there. That's why she's home. Okay,
Ms. Archer, it was a rough week.
I know it was. All right, classification of trust.
I was actually gonna let you know I don't catch up on no reading.
Oh, God,
But
another
next-
admission.
But next class, I'll be catch up on everything.
Yeah, I hear that. I am so happy to learn that, but I won't be here.
Where you gonna be?
Yeah, but I last class with them.
Yes,
Yeah, how come?
until I come to do the exam review. What do you mean how come? Did you check your schedule?
The first day.
Yeah,
Stop reading the book upside down. You even wrote on it right, go back, right here. Last class today.
Oh, shoot.
And you have Mr. Wilkinson and you have Ms. Dorset, and then I'll come to do the review. And someone is going to be sending me an email to remind me to send the cases for the exam. So that
Yes, that's me.
Guess what? That makes it even more wonderful. You know why? Because when I come to the review and I say there are certain cases you need to know, you all should be able to tell me what those cases are about.
Yes, and if we have any final questions on the
Yes, you can,
cases.
on the cases you can ask.
Okay,
Yeah. But you had to have read it before, because I'm not
right,
gonna tell you.
Yes.
You tell me.
okay.
What page we on now?
We're on unit 3 and we're going very fast. Because we have to do 3, 4, and 5.
And that would be page,
29.
thank you.
This book look new, not a air, not a pen print, not even pencil. Oh, add the Andrew name on there. She's online.
Okay.
Yeah. Oh, you don't know her?
No.
Deandra, we have Nathaniel come so she could see you.
Oh, I
Because she
see
was
her?
sitting where you're sitting. Yes, she's right there.
Okay, hi.
Hi, Nathaniel, nice to
Nice.
meet you.
Same to you,
She
beautiful.
heard a lot about you.
Okay,
How come you don't know much about me?
What you mean? You was in class, you talk. You know.
Okay, are you telling my business?
Well, it's recorded, yes.
just your future plans.
How many give me? I need a 3, 2 more.
Okay.
Trustee,
I don't need the trustee.
you have one? No, not the legislation. The deed. I gave you
Oh,
sample deed.
that's the one last week? Okay,
That
you
you
did.
didn't get.
Yeah,
That's right,
okay.
sign it.
Yeah.
Oh, you have your act. Oh my God, look at her.
That means that you-
Did you print your trustee act?
No, I didn't.
Oh, okay.
Don't worry, I can think, get it done in a minute.
Oh, Jesus. So,
They say nothing, you can sneak off on you.
yeah, very quick. Just press and go.
Yeah.
It's not gonna take long. Cause she looking. What you mean getting yourself into? This is an interesting topic.
It is.
Now let's go.
Uh-huh.
What's a simple trust?
A simple trust is one that does not impose any active duties on the trustee.
Mhm.
The law imposes such duties on the trust.
And I gave you an example.
Yeah.
When I said in the book,
Oh, I leave all of my estate to Adam to hold on trust for Benjamin.
that's a simple trust.
Right.
There's no duty involved in that. So when you go to a special trust adds on the duty.
Right.
Mm.
So it's not just only holding in trust, but I want you to do something on my behalf.
Okay.
That's a difference between a simple and a special trust. What's a statutory trust?
They are created or implied by statute. Example is when a person dies, it just states their property vests in the personal representative.
You understand that? No. So when you write a will, you say, I hereby appoint WA as my executor. So what it's saying is, by law, once you accept this position, it puts you in the role of being a trustee. That is why at the end of the day, if you do not execute the will in the manner in which it's supposed to be executed, which means this will, you could be sued.
Really?
Yes, you can.
So that means I can sue my grand uncle then,
Why?
because he ain't following my great grandmother's instructions.
The instructions are in the will,
Yeah,
but then you should have sued him.
yeah, now I know.
Can an executor also be a beneficiary?
Yes.
So if an executor is a beneficiary and there are assets that are not outlined in this will, who gets those? The executor?
No, it's based on who's in the residuary.
Who's in what?
There's a last line here, which speaks to residual.
Oh, residual.
Mhm. And whoever's name in there. So if it is executive, then that's who it is.
Okay. Okay.
If it says to all my children, then it's all my children. Or it says only the Bob and Mary, it only goes to Bob and Mary.
Okay.
Yeah. So this person here, executor, if it's a male, executrix, if it's a female. Whether it's a will or you die without a will, and the court appoints, no, administrator, it's a different name. Collectively, this name and this name under the law of succession is called personal representatives. So when you hear this name, personal representatives is a general term. So you really don't know whether the person died with a will or without a will. But when they give the name of, they say it was a will, then you know it's an executor or an executrix. If they say administrator, then you know it's a person who died without a will. So I can take this off now, right? What's an express trust?
An express trust is one where a settler makes a declaration that certain property is to be held in trust for certain persons or objects.
So express trust is the one we spoke about last week. That someone walks into a trust company and say, I want to establish a trust. Or a person says to another person, I will transfer this property to you on trust for. It's express, it's coming out, it's verbally coming out.
Okay.
And of course, for the three To satisfy an express trust, you have the three certainties. Remember, we mentioned those last week. And then you have the statutory requirements to transfer the assets. And express trust can be divided in two ways. What's those two ways? Express trust could be by intention and by law. You see it?
Yes, I see.
Mhm.
Thank you.
And by law. The executed versus executory trust simply means what it says by the name. An executed trust means everything has been done. It's complete. Assets has been transferred from the settlor to the trustee. And the trustee now, the property has vested into the trustee. So this means that all has been done. Executory means that there's still something to be done. Go ahead.
Yes.
Executory.
Executory.
Mhm.
Like you don't have that in the same time, though. Like trusts now are all outlined, or we still have executory.
No, you could have an executory trust where someone came to you and began the conversation, but never finished it.
Okay,
And let's say they dropped dead.
okay.
And so someone, a family member may say, you know, Nathaniel came to your office to establish a trust. We want to know what the trust says. And so when the lawyer or the trust officer pulls out the document, he sees it wasn't completed. So it's an executory trust. It's not finished.
That's not legally binding.
No. Because it'll have to be executed. Yeah. A completely and incompletely constituted trust. What's the difference?
The completely constituted trust is a trust where the settlor, having made his declaration, either declares himself trustee or conveys the property to the trustees in accordance to the formalities for the transfer of that type of property.
Right.
An incompletely constituted trust is a trust where no property has been transferred into the trust as is required by law. In consideration of the nature of such trust, it should be argued that no such trust exists in equity.
Okay, so the difference between an executed and executory trust versus a completely or incompletely executed trust is this one has to do with the creation of the trust, and this one has to do with the transfer of the assets. So let's just say they had finished all of this here. They told the trustee, these are my assets. These are my beneficiaries. And this is how I want the assets to be managed. So he's finished that part of it. But here is talking about the transfer of the assets from the settlor to the trustees. Because remember last class, I told you, based on the assets, each asset has its own method of transference. And the trustee has to make sure that happens, so that all of the assets vest in the trustee in order for him to take the legal interest. Got that, Nathaniel?
Yes, ma'am.
I hope so. Don't write no funny names.
I got it right.
Hey,
here.
Ms. Archer, can
Yes,
you say what's the difference with the completely and incompletely constituted trust again, please?
okay. Completely constituted, Nathaniel. What is that?
completely constituted.
Mm-hmm.
That means that the assets has already been approved from the
Wrong word.
from the executed to the complete, and they can now transfer it to the what you call it? It's already being given to the settler, and they can now execute the assets.
Trustee.
Trustee.
Right. So it's a fully executed trust, Deandra. And that completely means that the assets are going to be transferred from the settlor to the trustee.
The completely is a fully executed trust.
Yes.
Yes.
And an incompletely constituted trust is where the assets have not been transferred properly.
Okay, thank you.
All right. Then you have private and public trusts. What's the difference?
A public trust is a trust which is intended to promote the public benefit of public welfare such as charity, such as refers to as a charitable trust, whereas the private trust
It's the very first paragraph, first sentence.
express trust created for the benefit of an individual or class of beneficiaries is a private trust. Even though there are categories of purpose trust and charitable trust, an express private trust must be created to identify the individual.
Right. So you could have a private trust, but could be a trust just for my nephews, because that's a class, or just for my grandchildren. When you have a public trust, it'll be like how we were saying last week, is for charity,
Okay.
for the wheels, for the trees, for the cows, whatever. Then you have discretionary, and then you have fixed. What's the difference?
The discretionary is one where, let me read it. I read this part. A discretionary trust is a trust where the trustees are given the discretion to make a payment of income or capital or both to a certain beneficiary or class of beneficiaries under a trust. A fixed trust is a trust which provides for fixed interest for the beneficiaries under a fixed trust. The trustees have no power to alter or withhold such interest unless required by law.
Okay. Nathaniel, what does that mean?
Based on my limited understanding right now.
Why you have to qualify your understanding by saying limited? There's no need to do that. Deandra, you get ready for secret trust.
Yeah, from what I understand, that the discretionary trust is where a trustee can basically make changes if they want to.
Not change it.
No. Go ahead, answer.
I think a discretionary trust is one where, let's say there's $10,000. You say you want $10,000 for a car. The trustee can say, this isn't necessary at this time, now the $10,000 for medical or something, they can make that decision. But they determine if it's 10,000 really needs to be given to you for this car, for this party, for this whatever. Or if it's to be used like medical expenses to pay a mortgage or stuff like that.
They make that
They
decision.
make that decision.
Yes,
Whereas the fixed
fixed
one,
is fixed.
right.
That's what
He
I
can't be changed.
Yes.
What's her name? Hold on, I can look at it right now. Ashe? Okay, what's a protective trust? I'll give you the easy one.
Protective trust, a trust which are created to prevent a beneficiary from disposing of any or all of his beneficial interests. These trusts are designed for spendthrift or wasteful beneficiaries.
And remember, we spoke about that last class. Nathaniel, you were here. You understand that one?
That's,
Not too much.
that's
Okay.
if a protective trust is, let's say there's a beneficiary who could be a drunk or whatever, that's spending.
Drug addict
Drug
or
addict.
shopaholic.
Yeah,
Mhm.
so this protective trust would prevent this beneficiary from getting all the money at once because of their habit, basically.
Okay, Deandra, over to you.
Okay, a secret trust, I think it's saying that it's a trust that is made under will, intended for a purpose that's not revealed in the will.
Start by saying what? Yes, you started by saying in a will, but say there are two types of secret trusts.
Right, so it's a
Half
fully,
secret.
Those go.
Why?
Yeah.
Students always ask, that's the first question they ask, why are you so nosy?
Why, like, why, if this is in the will, why are you, why?
The name of the beneficiary is not in the will. In my will, I give it to Nathaniel. But Nathaniel knows what to do with it when I die.
So how is that worded in the will?
It's not worded like that. That's why it's called secret.
So how does the executor know?
He doesn't need to know.
Why?
This would be, I guess, based on prior conversation. you would have
Yeah.
had with the doctor.
Mhm.
So he knows.
Right. The deceased,
Yeah.
but he knows.
Yeah.
So he knows when he gets that $20,000 or that $50,000 or that land is conveyed to him. It's on him now to do what he's supposed to do with it. Well, if she don't trust you, you can see, but look at her eye. Based on the deceased instructions, yes.
The instructions that the deceased was going to give it to me. Right?
Yes, yes.
Right, but, okay, so there's a will, right?
So why was it will?
Right,
Hmm?
So why was it will?
it's
What
not,
do you mean?
Why put it
It-
in the will? If it's-
But how was he, when he dead, how was he supposed to get the property to him?
Yeah.
Or the money to him to do what he asked him to do?
Yes.
He doesn't want everybody to know, whatever that is.
Okay.
Maybe them fellas up outside children, they will take care of it. I said
Yeah,
it for you.
yeah,
I said it for you. I
yes.
said it for you.
Okay, thank you. I didn't want to say it. Now, look at her now, she worried now whether it's something that she's supposed to know that she doesn't know. Deandra, let's go and come finish
You don't wanna
explaining
give
this.
nothing to me yet, man.
Okay, the fully secret trust will appear in the will as an absolute gift, and the beneficiary under the will is informed of the trust outside of the will. That is, it does not appear on the face of the will. The testator having told the legatee of the purpose of the trust outside of the will. The testator must communicate the fact that sorry, say it again?
Testator.
Testator, okay. The testator must communicate the fact that the property is to be subject to a fully secret trust to the legatee under the will. The communication must be made at any time during the testator's lifetime. It is irrelevant whether the fully secret trust was made known to the legatee before or after the date of the will.
Okay, so stop right there. So that means that he can be called upon by the executor to say, this person left this for you. But the conversation with the person could have happened anytime in his lifetime. So let's just say he went out, had a one night stand. This girl got pregnant and he said, I don't want nothing to do with you. And she says it's his own. And he just dismisses it. Someone sent him pictures of it, but he mentions to his good friend one day, I had this one night thing, my wife can't know, no one in my family could know, my children mustn't know. And I have a daughter out there. If something was to happen to me, or if I'm to die, I need you to take care of her. No, he will say all that. He said, I just need you to take care of her.
Yeah.
So when he dies, and then a lawyer call and say, Mr. Chuck left you $200,000. He knows what to do with it.
Exactly.
But
Nah.
You don't think so?
No,
No, not for people like you, people with real money. They
Well,
do that.
there are people with real money because
Yes.
us, we Bahamians. Yeah, you had your child outside in the marriage, but I go into the wife and I tell the wife that, hey, I have a
So
child.
you ought to talk too much.
That's the problem. That's why I say how this is what.
It works.
So, but still, it would be up to Nathaniel if he wants to, because this conversation only happened between the deceased and Nathaniel, it would still be solely up to Nathaniel if he
Yes.
wants to.
Yes.
Mhm.
Because
And then you would,
So I'll be on his conscience.
Yeah.
right, yeah,
Okay.
and the family doesn't know. I want to. Children wasn't getting nothing from before, so they still ain't getting.
He could do that.
I'm sure it's happening.
Yeah.
I'm sure.
Or be trying to find the person, and the
Yeah.
person, I don't know, on drugs, not here, then move on with their life, not checking. I just read this week, oh God, I didn't remember the country. This girl was made a princess. She was the outside child of the king. The king is 86. She is 50, between 54 and 56, one of those
Wow.
age. And she was made a princess.
Because he has no other children.
Yes,
But sometimes so he can keep.
yeah, he raised his family, because
Yeah.
his son is the prince and waiting to be the king,
Oh,
but
okay.
he's an existing king.
Okay.
And he had an outside child, and they just recognized her 2 years ago. Just recognized her. Yeah, exactly. So now she's a princess and getting to know her half brothers and sisters. So I'm telling you, it still happens.
Yeah, yes, of course. Now you know stop.
So he probably already had put a provision in his will.
Yeah.
He's a king.
Yeah,
Yeah.
You see what I mean?
yeah.
It's only us.
She pushed, yeah, you can't.
Yeah. You can't do that.
And half secret trust. Deandra,
Sorry,
the half.
I forgot it was on mute.
Oh, okay.
So the half secret trust will appear as a trust in the will, but the details are revealed outside the will. The conditions to be met for a half secret trust are that the testator must communicate the half secret trust to the legatee before or can you pronounce that, please?
Contemporaneously.
Okay, with the making of the will.
Yes.
Contemporaneously. All right, so the next trust is what? Charitable. What's a charitable trust?
A charitable trust is a trust to be created with charitable purpose by benefiting the community in some way. They are known as public trusts and are enforceable by the Attorney General on behalf of the state. A charitable trust is different from a private trust which seeks to benefit defined persons or a narrower section of the public. Charitable trusts have certain privileges such as certainty of objects, the perpetuity rule, and fiscal privileges. A charitable trust will not fail for uncertainty of objects.
What's objects, Nathaniel?
Um,
Remember, we say to establish a trust, you need 3 certainties. What are those 3 certainties?
Oh, you mean,
Perfect intention
Mm-hmm.
of that. And subject matter.
Yes. Those 3 things. You must know them. Carry on.
Charitable trusts are not subject to the rule against perpetual trust, but they are subject to the rule against promotion of vesting. That is, if a charitable gift is contingent upon the happening of a future uncertain event, it will be void if there is a possibility that the gift may vest outside the perpetuity period of a life or lives in being and 21 years. Additionally, most charitable trusts are exempt from income tax.
Okay.
I have one question.
Mhm.
If this is a charitable trust, they said they are known as public trusts and are enforceable by the Attorney General on behalf of the state. Explain that for me, please.
You have to get approval
Give
from
it
the
approval.
Attorney General in order to have a charitable trust.
Okay.
That's like churches and stuff.
Mhm.
They have to go to the Attorney General.
Anything that's a
Any
non-profit.
non-
And non-profit, yeah. And that's a couple of years. they want to do.
Yeah, trust me.
Mhm.
Maybe
Yeah.
6 years for my approval,
You know what?
because I have politically connected.
Wrong answer.
Okay, tell me otherwise.
Because you're not the only person who wait long. It
Yeah, I
has
know
to
that.
really be, you have to, if an application comes before you, you have to really, really, really be confident that it's going to be used for charitable purposes. So it's not a pass through my desk and go. It's not like you incorporating a company. And you say when you incorporate a company, it doesn't say, my business will be selling bananas. That's how it used to be. Now it's just saying that you going into business for whatever is legal. So of course, they incorporate them in 5 seconds. But when you say you're doing charitable work,
Mhm.
On a charitable work, I don't think we pay taxes.
no, you don't pay taxes. So first step to find out whether or not what you intend to do doesn't really fall under the exemption for taxes.
Well,
The next thing is this, whether or not your charity is being established for a different purpose. Could be to launder money,
I'm not sure,
or you could be funding terrorists. It will sit and wait.
Yeah.
The more you agitate, the more red flags you will get. Just leave it alone.
well, I have to know that, so.
Yeah. But when people keep coming, every time coming, is it ready? Is it ready? What's the rush?
red flag,
Yeah.
I work around it.
Doing what?
red flag.
What I'm doing now, I just set up my,
Oh, I see, Jimmy, you just left it alone and do
Yeah.
something else.
Yeah.
Okay. Thought you was doing charitable work without it.
I mean, it is still going to
What?
charity, but I'll pay the taxes, you know.
Now, for a trust to be charitable, it falls under 4 heads. What's those 4 heads?
For the relief of poverty, for the advancement of education, for the advancement of religion, for other purposes beneficial to the community, which come within the spirit of the preamble.
And that was found in the case of the commissioner's income tax versus pencil. So for your exam, I will give you a scenario of a charitable scenario. And you'll have to tell me which one of the heads it fall under. And is it really a charitable? No. You ever see a trustee look multiple to you?
No.
Okay, no, there's no multiple choice.
I don't,
I have to make sure you understand. What happened to you, Andrew? Don't panic home in the house.
No, I am not panicking because I know 2 weeks before the exam, you are going to give us a clear outline of what we are to study and the way we should answer these questions, because all of us are getting an A in this course.
Yeah.
That's right, speaking in English.
Can I get an amen, y'all?
Hallelujah.
Y'all killing me.
We coming.
Okay, so what's the purpose trust? Purpose trust. So you get bronchitis.
No, I had a little food poisoning. A purpose trust is a private trust which is intended to. You laughing at me, man.
They laughing. Typical behaving man when they get bronchitis. Let's be good. Oh, food poisoning.
No, I did get food poisoning.
took?
Count. Yeah, from Tuesday. Just get over it. A purpose
They
trust
don't
is,
believe you.
All right.
Go ahead.
A purpose trust is a private trust which is intended to benefit purposes rather than beneficiaries. As a general rule, such trusts are void. However, there are exemptions. In some instances, trusts which fail to be treated as purpose trusts arise as they are seen as failed attempts to create charitable trusts.
Mhm.
See also section 39 of the Trustee Act.
All right.
Now that's our act, right?
Mhm.
So you got it.
Mhm.
I definitely got that.
Okay, Deandra, implied and resulting.
Implied and resulting trusts. Resulting trusts arise from the presumed intention of the settlor, particularly in instances where he has failed to express his intention clearly. An implied or resulting trust would arise if a settlor created a trust of $300,000 for a life. Equity would presume that he intended the money should result to himself or to his estate on Amos's death. A presumed resulting trust may arise where two or more parties have purchased property jointly or in the name of one person and have contributed in different proportions. There will be an implied understanding that all parties will have an equitable interest in the property, or where in the absence of evidence, the party's intention, the voluntary transfer of property from Amy to Candy can in some circumstances give rise to a presumed trust where Candy is deemed to hold the property in favor of Amy. An automatic resulting trust arises by operation of law, notwithstanding the intention of the settlor or parties. This may arise where a disposition is made by Amy to Candy and trust, which leaves some or all of the beneficial interests undisposed of. Candy will hold the undisposed beneficial interest automatically on a resulting trust for Amy. Note that a resulting trust will not arise where a transaction fails to make any effective disposition of any interest. For example, where property is disposed of by writing as opposed to a deed. A quilts close trust,
Disclose.
which is a trust where a person or entity transfers property or funds to another person or entity for a specific purpose, which creates a trust relationship between the two parties, is an example of an automatic resulting trust.
You understand that?
No, that was a lot, Ms. Archer. Can you break that down for us, please?
The first clause, is that something like a secret or half secret trust? No?
No. A quis trust is where Nathaniel goes to the bank and he applies for a loan. And the loan is for construction purposes. Or maybe the loan is to purchase some goods coming from China. And he provides the bank with the invoice or the estimate to bill, anyone. The loan is approved and the funds are put to your account. If you draw off those funds and do not pay that person for whom the loan was applied for, that person can sue the bank.
The bank?
Yes.
How?
Because the bank is aware of the purpose for which the funds were granted.
So then-
It's a
Oh.
trust relationship.
But you know that the banks now,
That's why they give it to you in portions and stages.
or they just give it to you
Yeah, they can.
But
But you
it-
have to spend it for the purpose of which it was intended.
That's not,
Or they'll cut a certified check in your name.
no, the bank would send it to your account. Like,
Yeah, okay. In the Chris Close case, we're talking about people who doing business.
or regular building.
No, not that. Big business with companies.
Okay.
And so I say,
Yeah.
okay, I say, okay, I buying that truckload of those cups
Mhm.
from you. And you write up the invoice and you tell me I have to go to the bank for financing.
I didn't know just a business trust.
So why the bank wouldn't send
It's
it
not a
to-
business trust.
Why wouldn't the bank?
Chris
go down
Close, what?
To the vendor? Why wouldn't they make? it?
Because their relationship is not with the vendor,
Oh,
Remember.
okay, yeah,
right?
okay,
You banking with me,
yes.
we have a relationship,
Okay,
and that relationship is based on trust.
yes,
So if he discloses to me that the purpose of the loan is to pay for that, and the invoice says that is what it's to pay for, and he doesn't pay because he took the money and he spent it, that company can sue.
but how
So
could
you
the
just wanna
vendor,
get
how
paid.
could the vendor sue the bank though? That's what I'm trying to figure out.
They're gonna sue him and the bank.
Okay,
But
number one, how I get
your
your product from
I
bank?
get the money from the bank.
Well, the money ain't there, because he asked you to pay.
But why
You
you
can't
get
pay.
product to bank? So what if you from bank?
No, but you remember now, between him and the vendor, there is another contract.
Yes.
And what depends on what that contract says, the vendor's expecting to get his money.
Wait, okay.
So I.
So they two different, between him and the vendor is a contractual agreement. Between him and the bank is a banking relationship.
But if you go to the bank for, funds for, financial for a specific purpose, why would they?
They don't. Scotia Bank, Royal Bank, that going to you, and on you.
You have to pay it, right?
Exactly, because you have the relationship with them. not the
Yes.
vendor.
Mhm. If you go spend all that, so you go to Dubai, that on you. But that person. nah, I
So
don't
even,
know that
so,
person.
so like say in the offshore world, the money will go from the bank to me, and then I send instructions and tell them transfer it from
Yeah,
me
yeah,
to the
yeah,
vendor.
yeah.
Because the bank knows that's where the money's supposed to go. So if I have an invoice in front of me from a gentleman who has IBC or whatever it is, but he has an account in what the name of the company. And he sends and he says, I need to borrow, or I just borrowed some money based on this contract here that I'm going to pay. You cannot take that money and send it somewhere else. You can't
I
do
mean,
that.
like you said, like we dealing with.
And that's a question that
That's-
comes to you
yeah.
in compliance.
Yeah, yeah.
If he has an invoice to pay Nathaniel, why is he sending the money to you? He has to send that money to the name that's on that invoice. Because then he's going to make the bank liable.
Yeah.
So you're talking about, it's different laws. His contract with the vendor is contractual law. His relationship with the bank is a banker-customer relationship. And the banker-customer relationship depends on the service being provided, gives rise to a fiduciary duty. And that fiduciary duty, that word means it's an element of trust.
Yep.
And remember, bankers are held to a higher standard than the regular man. So as a banker, there's certain things you should know. All right, so let's go back to our implied, presume, and automatic. So automatic, let's start from the bottom. Automatic arises by law. So they're not looking at the intention anymore. They're not looking at what was in the minds of the person. So what the law does is it looks at what actually transpired. And remember, trust is based on equity and fairness. To be just and fair. So if I have a piece of property, you know, everything always goes to 100. And I only transfer 80% of the interest. Then what? It's automatically presumed that the other 20 is for me.
Oh, yeah?
Uh-huh. Yeah, it's common sense.
Yeah.
Being fair and being just,
Yeah.
not being greedy.
Mhm.
The greedy one said, no, she made a mistake all for me.
Yeah.
No.
Yeah.
You call it.
Very.
This feels good. That's why he's coughing. 'cause it's
Yeah,
cold.
yeah, it's cool. Bring it up by bronchitis.
Yeah, they have bronchitis. We need Buckley's. So a presumed resulting trust. Note it now, they put the word presumed before it. The other one was automatic. So with a presumed one is where two persons purchase property. Okay? But it's only in the name of one person. But the two persons could have contributed towards that property. And so that's why they say it's a presumed resulting trust. There is a presumption. And the presumption is that they would have interest. So let's just say, go ahead. Go ahead.
This all for trust all together, right?
Mhm.
And that is why, when you have property and stuff, you get your property on your own. Because this brings
Oh,
comes into marriage and divorce.
But that is what this case is about, guessing and guessing.
Really?
Yes.
That's why you get paid on your own before you.
Now, because remember now, different laws can cross over. So when the judge is going to make a decision, he has to decide what principles he's going to use.
So.
So
if it's
I'm
my-
trying to find something to cook somebody, let me know.
No, that's like, I have a property, or I have a house,
Mhm.
I get married. And then because my husband gives equitable interest in my home, because he's paying some bills or.
Yes. Mhm.
You know, but-
This is the case. Look at it.
No, but that's true, you get to take before, and you don't live where you.
You leave and put it
You
on
leave your
rent.
house and then if anything, you leave your house, you put it on rent, and then you go rent. That's what it says.
Mhm.
My rule is 5 years to be married, and so we're looking for you, I don't know. They far from the home. Y'all deserve it. It's the truth. Because that person could come, that's your house, that's your, everything was yours, he come in there, because he's paying the bill. Now, I got to pay you off. It will pop up.
Oh, God.
When that, you see how fellas feel now.
An implied or resulting trust. Resulting means to go back. That's what it means. So if a settler created a trust and he says to Nathaniel for life, what does that mean? Just think about it logically.
That means that once the son dies, it dies.
It comes back to me.
What do you think?
I guess whoever you left as your residuary, whoever's your beneficiary, but it goes back.
How
to
that
them.
works with you?
Hmm?
You said you only.
Residuary.
But,
RESIDUARY.
So for clarity, Ms. Archer, you're saying that implied or resulting trust
Mhm.
means that if the beneficiary dies before the settler, everything goes back to the settler?
No,
Okay,
but you mean everything. It's just whatever is that disposition,
like,
that one disposition.
that would, they, the. Hold on.
Okay,
Let me
let's
use
just say
the
the
right
only,
word.
okay, let's just say.
The subject matter.
Mhm. Okay, if I use your example, where everything that he owns, he gave it all to Nathaniel. And he dies, it goes to his estate.
it goes to the second office.
Yes.
Sorry, I think, I don't
No,
know, my internet
I
probably.
I'm using your example.
Ms. Archer?
Yes, I can hear you. Can you hear us? You see, you should have come to class. Deandra, you can hear us? No, she isn't coming in. Drop. Have to wait for the cover. She's coming in now.
So,
Okay, you're in now, right?
Yes.
Okay,
ma'am.
all right. So what I was saying was using your example. If 300,000 is all that he has, that's all he has left. And he says, to Nathaniel for life. That's what he said. Then just like you said, if that's all he has, if he is still living, it goes back to him. And if he's dead, then it goes to the residuary.
wait, hold on. Wait, hold on. Doesn't the trustee gets the money and when the settler dies, that's when the trustee gets the money, right?
No,
What you mean?
This 300,000,
Yeah, but I give it to you for life. This means why you did it.
as I am living, right? So how does it goes back to the settler if he's already dead?
The settler don't
No.
want to be there.
You don't have to be dead.
Oh, now
Right.
I get it. The
Yeah.
11 trust.
Sorry, Ms. Archer, I think I'm
Yes.
just connected again, so I missed the entire explanation.
You miss it again.
Oh, she missed it.
I did.
That
Okay,
means the settler is still alive.
yes.
The settler is still alive.
Mhm,
Like I'll be putting the trust for my kids. I'll still be alive. So
mhm.
I understand that.
No, explain that part.
Okay. Just how you said, you setting up a person set up a
The
trust.
key to this is for life.
Yes, for life. So if one of them die, it goes right back to my estate.
Mhm, if you're dead.
If they die,
No, if you're
If
dead.
you are there.
if I get it goes back.
When you die, things go to your estate,
Right.
which means that any bills you have outstanding are paid from those monies.
Okay.
That falls
now-
under the law of succession.
Okay. Okay.
Because you do that, yes, plenty laws.
Yeah.
Go ahead.
so when it comes to bills, well, when you die, right?
Mm-hmm. That's the first thing comes out of all of your money.
Oh, okay, someone died,
Mm-hmm.
they were loan, a mortgage,
Mm-hmm.
these banks don't have it covered for life insurance.
Yes, they do. That's be the first thing they take over the
I have a
Not
friend-
everybody.
No,
What?
I have a
When they
friend,
stop doing that?
long time,
Okay.
I have a friend who husband died, and she lost the house because she didn't pay it.
Quite a few people in that position.
Yeah.
Okay.
They thought their husband had life insurance
I don't have life insurance, I don't.
and they didn't. Because I think in some banks it's optional.
It's optional, well, I know at Scotia it's optional, like on personal loans, but not in mortgage.
I don't know, life insurance, with mortgage, and I just found that out. When my friend husband died, I said, let me ask, and they said, no, you don't have life insurance.
And I know another lady who husband died and there's no insurance.
Mhm.
And she can't.
But Fenco, with Fenco, when I said Fenco, that was mandatory. As a part of it, but not social.
Well, at one point,
It wasn't mandatory, but now it's mandatory. Probably go back, let me go to the- go to the market.
That's another thing you have to think about.
Really?
Mm-hmm. You're talking about having life insurance for mortgages. Okay, sham trust. That was supposed to be Lovette's presentation, remember?
Hi, do you go to
We didn't,
back of the class?
Oh,
'Cause I can't hear any.
You coming, eh? Deandra, you coming? She still can't hear me.
Coming, well,
The class. Or you just can listen to the tape afterwards, the
You can get
recording.
them afterwards, you know.
Hmm?
You can get them afterwards. We can get them. Oh,
Miss Dean, must send it to you.
but they said me.
Did you ask?
But now I know too.
hi, Ms. Archer.
What you saying? You can hear me now?
Yes, ma'am.
Okay, let's do constructive trust, Nathaniel, your go. Come on, we have a long way to go.
Yes, I blame you for the code.
No, blame me. I told you what you have, bronchitis.
Constructive trust, trust which are imposed by operation of law by the courts as remedies where the conduct of a party makes it unjust that he should maintain the whole or part of the beneficial interest in certain property for himself. Constructive trusts are imposed irrespective of intention, either express or implied of those affected by it. A constructive trust appears to be to preserve property rights affected by unconscionable conduct on persons considered to be constructive trustee. A constructive trust will be imposed on a fiduciary who tries to make a secret profit from his fiduciary position. In the case of Boardman, demonstrated the following example of a constructive
What you mean, why you
trust.
run over the case?
I mean, in Boardman v. Phipps,
Boardman versus Phipps.
Of a constructive trust. If Mr. Battle, a trustee, wrongly took thousand shares in Milkstein Co. from the trust for himself and bought 1,000 shares in Yellow Company for himself when they were offered to him for the benefit of the trust, he would be a constructive trustee of all the shares for the benefits of the beneficiaries of the trust.
Mhm.
Constructive trustees are not subject to the same duties as an express trustee, nor do they possess any powers as a trustee. By imposing a constructive trust, the aim is to recover trust property from the trustee.
Or trace.
Trace the proceeds of the property if the trustee has disposed of it, or bring a personal action against the constructive trustee.
Bronchitis.
That's what the word will always say for everything.
You can hear the phlegm on your chest.
Yes, but from the core, from
No.
the.
From the cow?
No.
Poisoning have to do with the small and the large intestines, not the
that
lungs.
wasn't all of this. It was an infection as well.
Well, again, that's why you have bronchitis.
Yeah.
Buckley's, yeah.
You need the Buckley's, the green box. The green one, phlegm.
Yeah, this call.
$26.40.
$26.
Yes. But it's good, buy one.
I didn't know Buckley's, they still make Buckley's.
But you need
It's also
Buckley's.
better work.
That's right. So you realize constructive trust is where the courts, based upon the action of the trustees, so the trustee took the shares and he sold it to you. So if you were to go to the beneficiaries, go to court and they say the trustees took the shares and sold it to Nathaniel, Nathaniel then becomes a constructive trustee. Because it really doesn't belong to the trustee. It belongs to the trust.
Yes.
So it arises by law.
Yeah, but, so since he sold me and I became a constructive trustee, I still don't understand that because if it
Okay.
belongs to the trust.
Now remember now,
I need-
constructive trustee is just putting a label on it.
Yes, I understand.
You don't walk around, that's why the last paragraph says you have no power. You don't walk around to act like a trustee. All it's saying is that you're holding it by notice on behalf of the trust. It's not yours.
So when I die, it goes
Yeah,
back to.
nothing to do with dying. No, this is before the court. And the court realizes that you are holding property that belongs to the trust. Because the beneficiaries are suing the trustee because
Yes,
of something that he did wrong.
yes,
He disposed of property that was not his own to a third party.
yes.
That third party who's holding that asset becomes a constructive trustee.
Well, if that's the case, we have a lot of that going on right
Oh, Jesus.
now. That's the case. Mine ain't a lot.
Ashay, what's a sham trust?
trust document, which is not a trust. The trust may have been constituted in the sense that the trustees may be in possession of intended trust assets, and there may be a signed declaration or settlement. However, at the inception, there is no trust because the actions of the parties demonstrate a nominee or agency arrangement. The trust is incompletely or improperly constituted, or the actions of the settlor and our trustees negate the existence of the trust. Example, Robin case. In the
Which
Robin-
Levesque was supposed to do.
In the Robin case, the settler's behavior is aggressively and unilaterally dealing with trust assets and investments as he pleased, and the trustee's behavior in allowing him to act in such a manner. Subsequent to the creation of the trust, led the court to decide that the trust was a sham. As the evidence proved that there was no clear intention for the trust to operate as a trust, but rather as an agency or nominee arrangement. The sham doctrine, which most common law jurisdictions adopt, was enunciated by Lord Justice Diplock in his statement in Smith versus London and West.
Don't read it, they need to read it. Don't read the quote,
Okay.
everybody needs to read the quote.
Okay. It was also stated that the conceptual basis for the sham doctrine lies in the court's ability to see through acts or documents which are intended as a facade of disguise designed to conceal the real truth of the matter by settlers, trustees, and or their advisors, particularly in offshore revocable trusts, which are susceptible to legal scrutiny when it comes to sham trusts. Courts will often review and analyze the subjective intentions of the parties to a trust transaction. One of the key elements in their analysis is to determine whether all the parties to the transaction had the requisite intention to mislead those parties. Additionally, courts will scrutinize the conduct of the parties, particularly the settler's retention of certain powers and its control and dominance over the decision-making and actions of the trustees and the trust assets. In the Rahman case, Mr. Rahman retained control over the trust funds during his lifetime. Consequently, it was held by the Jersey court that the trust was a sham, particularly since the trustee was never made master of the assets. However, it must be noted that in bringing cases involved purported sham trusts, that the onus of establishing whether a sham exists rests on the party asserting that the transaction is a sham. Example, equitable maxim: he who asserts must prove. Therefore, it is the challenge of the plaintiffs in trust litigation cases to prove that a trust is a sham when commencing actions against trustees of offshore trusts. The standard of proof is a civil standard. That is on the balance of probabilities.
So in the Raman's case, but you see that after the finding in Snook, the Raman case, the settlor transferred his assets to the trustees. But he still carried on his business as if they were still his. So the trustee never took ownership besides the legal transfer. He never managed nor administered those assets. Raman did everything himself. And that's not what a trust is created for. Because a trustee holds, manages, and administers the assets of the trust. He was doing everything himself. And so that made it a facade. Now in the Bahamas, we have settler-directed trusts. And the settler-directed trust, remember last week what I said, they can make their own decisions with regard to investments. So it will not be considered a sham. He's only giving investment advice.
Okay.
In Raman's case, some of the assets were businesses. He was still running them like if they were his own. Yeah, can't do that.
No.
So on the exam, this question can come in two ways. One, I can select about 4 or 5 of these different trusts and ask you to explain them. Or I can give you instructions
And then
and ask you to tell me
Hey, that's the red.
what type of trust it
That's the
is.
route we should go.
All right? Validity of trust. Now, we know for a trust to be valid, what's required? Said it already today. You need three certainties.
Intention and subject matter.
Uh-huh. And that's one. All of them go together as just one.
Subject matter, object. and intent.
And intention.
Three certainties is one.
Oh.
Yes.
um,
You found the page?
I'm looking for it.
39.
Not looking,
Something else. Say.
no, I'm looking for what you
What?
guys asked for.
Satisfaction of any formal requirement.
Yes.
So it's the,
Yeah, that.
Go ahead, Deandra.
I'm not sure if y'all said it already, but I was gonna tell you, the three things that is required to make a valid trust.
Go ahead.
The three certainty is, the formal requirements
Uh-huh.
and the transfer of the subject matter.
Okay. Now, in the exam, you can have a scenario. And I could just simply ask you, is the trust valid? 1, 2, 3. Now, when you read the scenario,
We have that. because I know that is the term of the solid.
no, when you read the 3 points, you have to come to the conclusion as to which one of these three the question is directing you towards. Because the question may not speak nothing about formal requirements. So we're not interested in that. The question could be more towards just these. Or it could be just towards this, or just towards that.
And that's all what people say to the hour.
Yes,
But she's saying in her question, it may be like one of these.
it may just be one of them. Yes, it still
Scenario
won't be
is
valid,
one.
but you don't need to sit down and write about this and this, because that's not what the issue is.
Okay.
The question is always, what's the issue? Don't go all over the place like Natanya.
So when you say we do this review,
What?
the review.
Review is always done a week before. Yes, it is. Yeah, if I see.
Oh,
Okay, certainty of words or intention. Remember, intention has to do with the mind. Okay? And we always use the maxim that equity looks to the intent rather than the form. Because it's based on intention. So the court looks at the words that were used. And that's why I said in the exam, I can give you something that someone said, and you have to look at the words to see if the person intended to create a trust.
so that's like when you said that would be stat law would have gone and had a meeting concerning what he wanted to do, his intent, but it was not complete.
Yeah, intention, yeah,
Okay,
intention. But I'm gonna give you more or less saying what he actually, I'll give you the words that he used.
okay,
And you have to say whether or not the issue is certainty of intention, subject matter or object, or whether we're talking about formal requirements, or we're talking about the transfer of the trust subject matter. So it doesn't matter whether the word trust is used in his sentence, because that word trust is not important. It's what's his intention. Then I give you the case of Rique Ford that you could read. So with regard to satisfying the certainty of words or intention, it is important that the courts distinguish whether the settlor has the intention to impose a binding obligation. So it all comes down to, did the settlor propose, or was his intention to create a trust? Then I give you a little bit about the case of Ree Adams versus Kensington. So if you had a question, and the question is only looking at intention, and you're answering it in the exam, and you say, this sentence relates to certainty of intention, whether or not the settlor stated the correct words to meet this certainty. So it tells me you've already identified that the issue is certainty of intention or words. Your next sentence is going to be, in the case of Adamson versus Kensington, and you summarize it. And then you could conclude, this trust lacks certainty of intention, or this trust has met certainty of intention. Very short, to the point. You picked the wrong one, of course, all wrong. Yeah, but you picked the wrong certainty, it is wrong. Yeah. Certainty of subject matter. In order for a settlor to create a trust, he has to know his property. He has to know all of his assets. So he has to be in his right mind. And he needs to know the extent of his interest in those property. So not only must he know the property, he must know how much his interest is, whether he owns 40%, 100%, 60%. Because in order for him to transfer that to the trustee, he can only transfer the interest that he holds. Yes.
Can a settlor, okay. Someone died, left the settlor some property,
Mhm.
but it is in joint, whatever, joint tenancy, I think it is.
Mhm.
Can they include that property in their trust when it's joint? So joint is the one where it might die, if me and you in it together, it might die, it's all yours, right?
Mhm.
They can,
No.
why, suppose the other person dies first?
Yeah, but they did it.
Yeah, but so need to listen in case it is.
So it's still yours then.
It's automatically yours. So why would you need to do it?
Because I'm now putting it in my trust. I'm
How,
giving
but it's
stuff.
not yours yet.
It is mine, well, okay. Well, it's okay.
Gee, oh, Mr.
I just trying to see what we get. No, okay, so,
Okay.
you see what I'm saying, right?
The book's in there, that you still-
Right. Look at it like this, right?
I want-
Put it
Yeah,
down.
but don't forget now, how you could be transferring
You're not
that,
transferring.
no, you can't transfer that.
But if you put it like, okay, it's very different than putting it in a will.
Yeah, she could put her shares in the will.
No,
No,
but
she's
it's-
not gonna, she's not
the
gonna
share,
have
it's
a
not a
share.
share,
Yeah.
if that person
But-
dies first.
Right.
What, you made the joint joint,
With joint tenancy,
Uh-huh.
and me and you in it together, if
Yeah.
you die first, it's
Right,
mine,
that's
I
a
die
violation.
first, it's yours.
exactly,
So, I have children.
yeah.
I wanna put in my will that if you were to die first, it is sold to my children, can that happen? Because he may die today, I die tomorrow. So although he died first, it's still mine.
Well, why would you do that?
So
When,
my children can
if
have
it
it.
was, your children can still have it, if they add the residuary. Whatever you get after the will, whatever assets you acquire after the will is prepared, whoever's in that last line here, they get it.
Yeah, yeah,
And you say to my children in equal portions.
yeah,
Okay, okay.
simple.
Simple. Whatever you have outside of that. Let's say when you wrote your bill, you only had one car. And you sold it.
Mhm.
But in your will, you wrote one car to Mary. Well, Mary won't get anything because it's gone.
Yeah.
But if you, let's say you had one car, you say to Mary at that time,
Mhm.
2 years ago. But you were a collector, so you have 5 expensive cars that you bought after you wrote the will. Whoever name is in the bottom there, that's what goes.
Okay.
So it is important that there is a certainty of the trust property as it allows the trustees to know exactly what's to be included in the trust and what's to be excluded from the trust. The beneficial interests of each beneficiary must be certain in order to enable the trustees to know exactly what and how much each beneficiary will be entitled to receive on distribution. What income is to be accumulated or to be paid to the beneficiary. And then I gave you the case of Boyce versus Boyce. A trust failed for uncertainty as to beneficial interest, where a testator left several houses on trust for his wife for life, and on her death to convey any one house to his daughter Amy, as she might choose, and then the remaining to the other daughter Betty. Amy died before she could make a choice, and so this left uncertainty as to what house Betty would have gotten. So there was no trust for Betty. What happened? She read it again.
Right.
No trust was created because Amy didn't do what she was supposed to do. She didn't carry it out. So how could the trust be created? The subject matter is not known. Which house was she giving to her sister?
So,
So where else is?
Who have the houses?
What you
so
mean?
Betty should get on to that.
No,
So-
no,
So what happened to the houses?
Yeah, what happened to her?
she didn't make a choice. So whatever's instructions inside the mother, the will,
So the houses have to go to somebody.
yeah, but not to her.
That's where the residual comes in.
Mhm.
Okay. Yeah, that's what it is.
Yeah. So in the case of Spring versus Bernard, the testatrix left 300 pounds to her husband for his sole use. And after his death, the remaining part of what is left, and he does not want for his own wants and use to be divided between my brother and my sister equally. The court held that this was not a trust for the husband with remainders over, but rather an absolute gift. There could be no certainty as to what would be left for the brother and sister on the husband's death. And he was entitled to dissipate the entire fund.
Yes, I see.
And then I gave you the case of Hunter versus Hunter. So if the question has to do with certainty of subject matter, you have cases to refer to. I don't expect to see the 3 of them,
Right.
just pick one. And if you don't remember the name of the case, if you remember the story, you still get the point. It's important to understand that if there is some uncertainty on the subject matter of the whole trust, that can be doubt that whether trust was actually intended. Because without subject matter, you can't have a trust. mean, it just doesn't happen. Certainty of object, that's the beneficiaries. They have to be clearly defined. Where there is a class, such as my old friends, my defendants, there will be uncertainty of objects and the trust will fail. Because who are you paying the funds to if you don't have beneficiaries? So there are different types of certainty of objects and fixed and discretionary trusts. For fixed, the certainty of objects is that it must be possible for the trustees to prepare a complete list of the beneficiaries. But when it comes to discretionary, especially the classes, then sometimes you get into uncertainty. And that's where the case of McPhail versus Dalton is one that you should read. And it speaks to the criteria to determine whether or not there's certainty of objects. And I have the case there. So the test for certainty of objects is that it is possible to say with certainty whether any given individual is or is not a member of a class. And the trust will not simply fail because it is impossible to ascertain every member of the class. And they call this the postulant test. In applying the test, the description of the class must not be so obscure to preclude the trustees in determining whether any given claimant is within a class. Examples of obscurity are any person having a moral claim on whatever matter. It's too obscure. How would you know if someone have a moral standing on an issue? They could say yes now, so they'll be able to benefit, but they really mean no. Old friends.
That's,
Mhm.
secret. I agree to carry out whatever instructions we had initially.
Yeah, the secret and
Yeah.
top secret.
Mhm.
And then when you die, it's still solely up to me if I actually execute what our initial plan to what you want to do, if I do my own thing, right?
You mean that falls under certainty of object?
You're talking about the moral standard.
Not just moral standard, yes.
Yeah, you got the
Mhm.
secret and top secret.
Final decides to spend all
Okay,
the money or take care of the
Yeah,
children.
exactly. You don't want to
We
be
good.
accountable.
you don't know.
Exactly.
Now, unless there's another old person there who knew that Nathaniel was a very good friend. And they knew, and this old friend will say, I noticed after your daddy died, Nathaniel took us a house, bought a new car, or he renovated his bar, then it raises questions.
Yes.
And then when you do that point,
You still, you hire a lawyer to find out.
But how do you know what if it was, like how?
Exactly, because that
Because
was
it
just
was
between the
between
two of
the
us.
two of us.
He wouldn't know there's a trust. He'll go to the lawyer and say, my daddy old friend said that now Mr. So-and-so was a friend of my father. They're very good. And I just find it surprised that he didn't do anything for me. See, and then it also depends on the relationship between the father and the son. So if you know, based on your relationship, your daddy would not have left you with nothing.
Yeah.
Knowing that you are an outside child, but you know your daddy. Then you begin to question, well, if this man said Nathaniel was my daddy's best friend, my daddy must have told him something. Where did he get this windfall from? That's when the questions come to your mind.
Okay, so in that
Just
case,
hire an investigator.
so but the investigators will be determined.
If you can afford it.
Yes, but I just said it's not for poor people.
Exactly.
So the investigator finds that the Daniel did in fact get this money, but the investigator can't confirm what the money was for, so the family could say it was for everything.
But then that's why you take him to court.
but we didn't have to call based on,
If only him know what the money was for, he can say anything.
but then I guess it's why integrity and all of that come into play.
Mhm.
Yeah.
Yes.
From Daniel, let's do it, I think.
But then, but who's to say that what Nathaniel is doing ain't the right thing according to Nathaniel? Nathaniel thinks the right thing for him to do is to control.
That's not like you need to be in the psych ward then. That's something different. That's something totally different. Now, in the case of Butler, Oaks and Oaks, which is a Bahamian case, in that case, the testatrix will contain the following provision. I gave and bequeath unto my trustee to divide among such of my friend and relatives living at the time of my death, the jewelry, fine art, and other personality then owned by me in such shares and quantities as my trustees may select and appoint to them. Any such jewelry not so appointed by my trustees shall be disposed of as part of my residuary estate. It is my hope that in making said selections and appointments, my trustees will be guided by such suggestions I have made to them during my lifetime. The court held that certainty of objects was satisfied. As a relative of X was a person who could trace descendant from a common ancestor with X. The court applied the guidelines settled in the case of Reballo's Will Trust to define friends as the following. The relationship must have been a long-standing one. The relationship must have been a social one rather than a business or professional one. And although there may have been long periods when they probably didn't communicate, when circumstances did permit, they must have met frequently. So be very careful if you write a will and you say divide between my friends. Because I may not have seen you for 20 years. But the point is that whenever we met at the trust annual fair, we would walk together, drink together, talk and have fun. Or if I met you at the Red Cross ball, we decided to sit together, catch them all the time, I am still your friend. So when in doubt, of course, the trustees always go to court. So the additional requirements for creating a valid will, we just went through number one. There's two more.
Let me ask you a question. So when you go to court, right, and there's assets in the trust. And no one is getting anything because of whatever reason. There's no interest, no nothing, it's just sitting in trust.
For the asset, what do you mean no interest?
It's no cash.
Here the trustees have to bank it with a bank, and that's it.
Until the whole.
That still goes on.
Okay.
Yeah, that still goes on. No, escrow, escrow no on interest.
That's what it is.
He has to invest it.
Okay.
He has to invest it. So the settlor's legal interest, that's the second one, in the property has to be transferred to the trustee in accordance with the formalities of the law. Remember, we mentioned this already. Depends on the assets and what's required to transfer it from the settlor to the trustee. The object of the trust must also be lawful for the trust to be validly created. The settlor's capacity to create a trust. First, he must own the property and have the necessary capacity. Capacity means at the age of 18, which means he have to be able to dispose of his property. So he has to be 18. He also must have the requisite mental capacity. He must be of sound mind and understand what he is doing, the nature of the act. He must know what it means to create a trust. The settlor must also may also create a trust of the equitable interest in certain properties as well. So he doesn't necessarily have to just the legal interest. He could have an equitable interest and he could put that in a trust. Minors, though they hold an equitable interest in real property, do not have a legal interest in such property and they cannot create a trust, especially in land. Minors may create trust of the equitable interest in property and such will become voidable for the purposes of the law, which means they can, but not until they're 18. They can actually take effect. Like a will, when it comes to the legal requirements for mental capacity, it is necessary for the settler to demonstrate that he fully understood the nature of what he was doing, notwithstanding the fact that there may have been some mental incapacity previously. In the case where a trust may have been created by a settler with a history of mental incapacity, it is sufficient to prove to the court that the trust was created by the settler during a lucid interval. So that means that if someone is mentally incapacitated, it's normally advisable that you have a doctor present at the time it's being created.
That's the same thing as persons who are in hospital and then keep their will.
Yes.
So that's not. So if they create their will while they're in hospital, they ill from dying or whatever situation is, right?
You know, we have a doctor to say that or not.
But then too, it still wouldn't matter because if it's not registered.
Will's not registered.
Why?
No, it's personal, it doesn't take effect until that. So why would it be registered? Hold on one sec.
I think so.
Go ahead, ask the question again.
The will is recorded.
No.
Recorded. Yeah. Alright.
So how
You
to
can
get
keep
to
it
the-
at the registry if you wish for a week. You're gonna stamp from your attorney.
It has to be stamped.
What?
That's law.
It is,
Stamp there. At the registry,
Why you stamping?
so it can be recorded. Yes. I'm sure. No? Yes. It has to be recorded, even like the property and stuff, it has to be recorded.
No, I know property is recorded.
Milk store, has to be recorded.
I don't know what it is.
Mhm.
Local people?
right of will. And
You have to go to the registry, it has to be in the registry to make sure. You can have, I can write a will, I'm gonna put it in my drawer, who was to say that that's really what I want, that's a legal stuff.
Yeah, you can write a will anytime. You can write a will.
Yeah, but that's been recorded.
Where do you get that from? Look it up. Because the attorney bills are not recorded.
Right, that's why, and especially like back in the day, that's why the family used to do all kind of food to this.
They still do it. Okay. He thinking now of his will. Why? I'm sure you do. You have a car, right?
I mean, I have some things, but maybe that's work for
It still works.
It still works for something for somebody. Give it to your neighbor.
they fresh on the luck of it.
The registry. You mind if I put you on speakerphone? Okay, hold on. Go ahead. Kanika.
Yes.
Uh-huh.
So the only because I have to be recording. You can actually do a full name, wherever on the agency, or anything else. it just needs to be witnessed by two witnesses that are not, beneficiaries of the will. But there is a registry, which is before, it's a registry that you could actually, have your will kept there. So, but otherwise, you will have to register it.
Okay,
So upon your death, somebody would go there and get your will, but it's like a safety, it's not mandatory.
okay, thank you.
Mhm.
Where can I go get
So,
some?
Now I got some questions.
Okay.
Now I got a
Excuse me.
question. Why you spending $400 and $500 to go to the lawyer to get the will done?
Because they keeping it for you.
No,
And they're putting it
no,
together.
no.
Probably
it's
the wording ain't-
The wording. It's the wording.
I always. Why do lawyers have it that they have to? I've seen those that are stamped by the registry. Like recently,
Stamp before the person died.
yes,
What for?
I don't know.
No, I don't know that. That's what I was wondering where he's getting that from, because I was trying to figure if that was a practice that's done by your employer. You see what I mean?
No, that's not required.
I thought.
You can go to the registry, like she was saying, and you could have them store it for you for safekeeping. So you can tell someone that in the event that I die, my will is being kept in safekeeping at the registry. You can do that. But some people, like you said, they have it in their drawer at home, or they give it to a best friend or something like that.
I think.
But they keep a copy, right? They let them keep the original and they keep the copy.
Oh, mean at the registry?
Yeah.
You keep whatever copy you want. I never. Okay. No. And they charge you so much for something that they don't have to do.
If you go online to the Wills app, the very back, there's a template.
So you have to pay for it. Listen.
But then you have to follow the rules.
Afterwards, this is a hard fact for sure. Yeah.
Way to go.
And,
together.
and the witnesses have to be present both at the same time when you sign the will.
Do they have to sign?
They have to
Yeah,
sign.
yeah,
They don't have to sign at the same time. But when you sign the will, they have to be there and they have to be actually watching you.
So,
If someone witnesses being done, right? So let's just say Nathaniel is say he's going to execute his will now, and it's me and you, Ashay. And I say, I go to the bathroom, coming right back. But you just started the right, you just put in, and I go, and when I come back, your whole name is on this paper. That will is not valid. And then like you say, you can write a will on anything.
so
Anything.
can an employer, if I go to a bank, right? I'm a diamond star. I have this bill that he wrote at home on his paper. Can an employer say or determine whether or not they want to accept like whatever is outlined inside the will?
So certainly when you say employer,
Like if I go to a bank, right?
they're his
When his,
bank account is.
yeah,
Uh-huh.
can they like refuse to honor the will? Is that the time for a will? Or that's not to be probated? It's still have to be probated then?
Yeah, the only thing they're gonna give you is something towards the funeral.
Oh, yeah. For the bank.
Yeah.
Oh,
Office account.
that makes sense.
1,500, right?
Yeah,
Yeah,
thank
1,500
you.
by law.
The bank, what they would do.
Office account.
They will say, so I would have to go in as the executor to a child. Can I go in just as a daughter? Yeah, you can.
Mhm.
What's your best? Really? Yeah.
Oh, you can get, I could be a secret friend.
Because it's gonna be paid because they don't know. It's on the money.
I go to the bank and I tell them so and so that,
You're the best.
and then
And
they.
what's your relationship with the deceased?
No, I don't know where that we can.
No, but then don't forget, this is not free money now.
Yeah,
This
also
money on
money,
his account.
Yeah, and if he doesn't have it, right?
yeah. You give it a max or whatever it is, that's not, if it's not the max.
Right.
But if it's, there's
Now,
more,
some
you
people-
can't exceed.
Some people, when someone dies and they go through the draw and they see Scotia and the bank account, CID, then they go to a wallet. All the credit union and all the banks.
And each one of them, the 1,500 or whatever they want. No,
No.
The
They're gonna
lawyer-
ask whether or not there are any accounts in this name.
once a lawyer writes that you could release the information to the lawyer. Okay, if there's a conflict that we got, so that's everything. But that's $1,500.
This is a one time,
Okay.
one
So they will
set,
settle the whole
nothing
thing.
else.
So I can't go if we use this. It's not really that easy.
It's a one-time thing.
I can't go tomorrow. But if you go
Deandra, you can hear us
If
now?
I go- If you go today and I go tomorrow, then you won't give me anything.
Most stuff.
Okay. We're talking about funeral and wills now.
Okay.
Okay.
That's all.
Well, that is why it's so important that you prepare for death. And that's why trusts are so important, because trusts, you do not wait for probate. That's the difference. Okay, the rule against perpetuity, I give you all a little bit of history. But if you turn to the next page, you'll see that we abolished the rule against perpetuity. That's what's important. Against Perpetuities Abolition Act. So for dispositions that were created before the 30th of December 2011, the trustee must make an application to the court for the court to declare that the rule against perpetuity has been abolished by virtue of the Rule Against Perpetuity Abolition Act 2011. That's another one that you have to print, Nathaniel.
What's that?
I think it's on page 9, all that you need to print.
On page 9?
The Rule Against Perpetuities Abolition
It's
Act.
not page 9. It's not page
Right,
9.
right, somewhere. That was the one you did when you came to class, remember?
Page 12.
12?
Uh-huh.
Yeah, right up in there.
Study results.
She followed instructions.
Where it is?
Bahamas Financial Services Board.
Mhm.
I think there were 1, 2, 3, 4, 5. Is it 5? Legislation that we really need to know, that was the Trust Act, 1998, and its amendments. The Perpetuities Act, Proceeds of Crime, Anti-Terrorism, Financial Transaction, Reporting and Regulations, the Act and the Regulation, and the Financial Transaction Wiring Regulation. That's all you need to know under.
You don't need another wiring.
Okay. So, Trust Act.
Hold on, you printed those out.
I don't know. Everything on this one.
Oh, wonderful.
And then you print it probably. So.
Mhm. Yeah, fraudulent disposition, the choice of governing law, that just says that the trust is governed by the laws of the Bahamas. And you. And it's probate, and it's the administration,
And then this is.
that's the rules, and that's the act.
Yeah.
And then you want to finish this in terms of the probate, with
Mhm.
succession.
Okay.
Succession. This only here speaks to probate. You have the Wills Act, you have the Inheritance Act, and you have the Status of Children. The Status of Children Act covers, change the law that all children are
Are
equal.
equal,
Yes,
right.
so we have the Status of Children Act. And then you have the Inheritance Act, that's when you die without a will, and where, the law states where your assets.
So once you die without a will and all children are equal, right? The children not in the household or of marriage, they are all children are equal, with all children. I have a friend who just recently died, and he's fighting back with the 70s and outside child. And he's fighting because the children with the dead mother didn't want to see outside children anything. Oh, and it's the assets.
Did the father sign it, right?
Well, now he did, trying to fight for it. So.
Yeah, once he signed.
Once he signed,
He signed.
yeah, if he didn't sign, then of course, that's another
And
procedure
all
to
of
go
the-
through.
All of the outside children he signed for, and all of the outside ones, are the ones who don't didn't get anything.
I didn't do it. I didn't know it.
Well, all this is go first round, on 11. You see the kind of training is doing. Really, it's not that.
All these acts, we gotta,
So, the trustee act,
The Trustee Act, you have to read in all of its amendments.
the trustee act, the perpetuities act, the Seeds of Crime Act, anti-terrorism. The perpetuities. And then come down to the Seeds of Crime Act, anti-terrorism, and then to conduct the Credit Act and resolution. Yeah. the crime.
Okay.
So we don't have to do by said trust companies, no, right?
Well, if you never read it, you could do it. That governs facts. That's companies. Remember you were thinking of
Yes,
applying for a license? Yes, that falls under that.
And the lottery.
All right, look at your deed. That choice of governing law act, that's paragraph 1. Oh, don't turn it right on the front.
Okay.
See, it says subject to the powers conferred on the trustee by clause 14, and to each and every exercise thereof. The proper law of this trust is the law of, and you'll see the Bahamas. Oh, yeah. See. Understanding that the trustee, thank you, may from time to time be resident or domicile elsewhere than in the Bahamas.
Excuse me, Ms. Archer.
Hi there.
What, are we reading out the book?
No, remember the handout I gave, the trustee?
Yeah.
Okay, paragraph 1 says proper law. That relates to the legislation called the choice of governing law.
Okay, you may, okay, so we under proper law, number one.
Look, you can see this.
Uh-huh.
Okay. Proper law relates to the legislation called choice of governing law.
Okay.
What?
Which one that is?
Right there where your thumb is, right where your thumb is, go down to point number 1, paragraph 1. You see what it says? Proper law? Yes.
I think I have the wrong word.
Right here, proper law.
Oh, proper.
Yes. Right there.
No, I heard you saying something about the Bahamas. and I-
No, it's blank.
Oh.
And I said the Bahamas will
Oh,
go
okay,
there,
okay.
or Belize will go there,
Okay.
any one of those jurisdiction. Now, let's see. And then when you look at, go to the next, what page is this? Can't see number. Let me go to paragraph. Paragraph 6 speaks to trust. 6(4). Power of appointment during the lifetime of the settlor. During the lifetime of the settlor, the trustee shall distribute the trust fund or any part thereof to such one or more of the beneficiaries on such terms and conditions, either outright or in trust, as the settlor may from time to time appoint by signed written deed delivered to the trustee, with such deed specifically referring to and exercising this power of appointment. Remember, we spoke about the difference between a trust and a power earlier. Notwithstanding powers of appointment limited, notwithstanding anything else in clause 6(4) or 6(5) to the contrary, the powers of appointment set forth in clause 6(4) and 6(5) are non-general, limited powers of appointment, and therefore, notwithstanding anything to the contrary herein, such powers of appointment may not be exercised to any extent or in any manner in favor of the settlor, the settlor's estate, the settlor's creditor, or the creditors of the settlor's estate. So you see, they've excluded the creditor out of this completely in terms of the power of appointment. Now, trying to see if I can find clause 16. No, 15. 15 speaks to perpetuity. It says the trustee may by deed revocable or irrevocable at any time declare that a day earlier than the day mentioned in the definition of the trust period in clause 2, but not earlier than the date of such deed shall be the date of the expiration of the trust fund. And if you go back to page 393, the trust period is defined as the period from the date of this deed until the day on which shall expire the period of 80 years in this trust. Clause 16 speaks to the protector. Remember, we mentioned the protector earlier? So the first protector shall be the person specified in the third schedule. At the very back is just a template. It doesn't give you the name. So you could put the first protector be Nathaniel and then whoever's going to be afterwards. And then it tells you what the protector can do.
The protector shall have the power by notice and writing to appoint one or more other persons or corporations to be an additional trustee hereof, or to fill any vacancy in the office of trustee, and to remove any trustee, provided such power to remove any trustee shall not be exercised unless there is a remaining trustee, or unless by such notice the protector shall appoint a replacement trustee. So you see the power to appoint and replace trustees is given to the protector. Upon receipt of such notice by the trustee being removed shall cease to be a trustee hereof to all intents and purposes, except as to acts and deeds necessary for the proper vesting of the trust fund in the continuing or new trustee or trustees, otherwise as the case may require. And now go to your unit 5. Who may be a trustee? A trustee has to be someone of sound mind and someone who is not bankrupt. You cannot have a thief or someone who has misappropriated funds as a trustee. What's a bot? Let me hear your bot.
To be considered a thief, they would have to be.
Yes,
Before the court.
declared so, yes.
Okay.
Yeah.
That's all I'm.
Yeah, oh, okay,
Not-
yeah.
not no hair
Yeah,
sip.
and no. But I mean,
Yeah, we know.
if you have hearsay and you trust that person with money and something happens, you know, you're gonna be sued.
Yeah.
Okay. So a trustee must be the legal owner of property, including real property.
Where are you reading from, please?
In the notes now,
Okay.
appointment of a trustee.
Where's that with page?
I don't know, what page is that?
48.
48. And of course, a trustee should be of legal age. A trustee, just like a banker, have to have that high level of integrity. They have to be trustworthy. They have to be commercially aware, because one of their main duty is the duty to invest.
Yes.
So they have to know different types of assets, different ways to invest those assets and administer those assets in order to have a return for the beneficiaries. And of course, they have to have the due skill and care. And the act itself gives them the authority to go out and solicit expert advice when needed. So not only can an individual be a trustee, also a company can be a trustee. And you know that because in the very first class, I spoke about the number of trust companies that we have here in the Bahamas.
That's kept secret.
It is not.
What you say?
It's the best kept secret.
Well, we could have went.
Well, if you're putting money in trust and you want me to administer and hold it and manage it, well, it'll have to be of something. This is not farming where you give me a seed and then I grow an orchard.
Yeah.
Okay. And then we spoke about, Deandra, the question this morning on the two main types of licenses, either restricted or unrestricted license. Professional trustees are often held to a higher legal standard of duty, care, and skill than individual or personal trustees. Because remember, you can make me a trustee as an individual. But if you are part of a trust corporation, it's at a higher standard. So whether a trustee is an individual or a corporation, the duties and the responsibility is very onerous. And of course, it's a lot of time consuming because you're administering and managing assets. And so you have to give this job your full attention, skill, and care as the trustee in the administration of the trust. Notwithstanding the fact that trustees may insure themselves against liability. So there is insurance coverage, but that doesn't preempt you from exercising your skill and care in order
not to be sued by the beneficiaries for breach of trust. So the actions and decisions of the trustees are constantly under the scrutiny of the beneficiaries and the protector. And the potential of breach of trust is always like looming over their head. So how is a trustee appointed? A trustee is appointed at the very beginning, when the trust is created. That's the first time.
Yes, by the settler.
Depends, yeah. Because he decides which firm, which corporation he wants to go to. A trustee could also be appointed as a substitute. So say one died, or a trustee retired, or removed, because the court can remove a trustee.
Only way that can happen is if some season this behalf of this man.
Or the beneficiaries cannot get along with the trustee. They will go to the court. Or,
I mean, in a case like that, I mean, it's your money I manage it, and if you don't want to keep, just like a bank, if you don't want me to manage your money anymore, just take it and go to a different thing. You know,
how you taking your money? How are you doing that?
because only thing the trustee is keeping it and managing it for the beneficiaries, right? So if the beneficiary said, "Hey, I don't want you managing my funds," it's just like an asset manager. If I don't want you managing
No.
my asset,
Different.
no?
Uh-uh.
Okay,
Mm-mm. You can't just take your money and go,
okay,
because beneficiaries only have equitable interests.
yes,
The title belongs to the trustee.
yes. Now I understand.
Or appointment of a trustee can be because you want an additional trustee. So the new trust, the trustees are appointed by the settlor. We agree to that. Okay. The settlor can appoint himself as a trustee, or he can appoint other persons as a trustee. So appointing himself as a trustee is when he say, I purchased this property, but I'm holding it in trust for my son. Okay, that's a simple one. So once the valid transfer is completed, the trust will be completely constituted and remain valid. So in the example I just gave you, he cannot convey to the name of his son if he's under the age of 18. Okay. Where there are no trustees appointed, the court may appoint trustees. And they do that so that the trust can be administered, because the trust can only be administered if there are trustees. The trust property will vest, as always, in the first trustees, and then all subsequent trustees. So when a trustee is replaced, then he takes the place of the other one. And they all hold it jointly. Because remember now, as a trustee, they all become one to manage those assets and to preserve it for the benefit of the beneficiaries as a whole. Now, testator in his will, and here we use the term inter vivos, and inter vivos mean while you're living. So a testator may appoint trustees in his will. The legal estate in the trust property vests automatically in the executors at his death. And then where there is an administrator, the title relates back to the death. While living, yes. So if the trustees who are appointed die before the testator, right? Or
that no trustees were appointed by the testator. Or that the trustee appointed is legally incapable of taking that position. A will that will not cause the trust to fail. Even though the will may contain no provisions to appoint trustee. Here, the executors or administrators will be deemed to be constructive trustees until trustees are appointed by the court. So where the same person is appointed as executor and trustees in a will, once they have completed their duties as executors, then their appointment as a trustee automatically arises. So it's not a simple task when someone puts you in their will as executor and trustee. That's a responsibility. And you'll have a duty to account to the beneficiaries. And of course, if it is land, then you need a deed of assent. It's important that trustees disclose any potential existing conflict of interest prior to the appointment of a trust. Because it's a fundamental principle of trust law that a trustee may not place himself in a position where his duty as a trustee conflicts with his personal interests. You can't have a conflict.
Okay, so just on that, I guess.
Go
So,
ahead.
If I enter investment properties, there, as a trustee, I cannot trust properties. Meaning
No.
that someone want to put me because they know I'm into investment properties. They want me to act as a trustee for their beneficiaries because they're buying properties and they want me to make sure that they manage the property properly.
That's not something you're trying to do. Break it down.
Okay,
Who's pointing out?
all right. Like I said, I'm into investment properties, right? So
Now, when you
I
say
build-
investment properties, what do you mean?
meaning buying land and building condos on them. Right?
And selling them to who? To public?
Yeah,
Okay.
right. So their dad buy properties and so forth, and he want to make sure that their husbands can't take it from them. So he want to make sure that they invest in property for their benefit and it can do so. He put me as a trustee to
No,
make sure.
that's
Mm.
my word invest.
So because you said it can't be a conflict of personal interest, because that's what I'm into, but
No,
I
you
don't-
trust me because that's what I'm into.
No,
You know, that's my expertise.
Hold on, Nathaniel, tell me this, what you're saying. You're saying that because you invest in properties, right? My dad, he wants to give me a piece of property, but my husband or whoever don't make sense. So my dad just wants to make sure that my husband doesn't get it, right?
Yeah.
So he is trusted. You are his trustee.
Uh-huh.
no,
No.
No, he put me as a trustee for her as the beneficiary.
So now, why
Because
not
of the
just
type
do
of
a
business
will?
I'm doing.
Why not
Because
just
of
do
the
a
line of
will?
work.
Like,
I mean, like. because
yeah,
of
but
the
how is he
business
putting
that
him
you
as a
have.
trustee?
because I'm a building contractor who's into investment properties.
No, but it won't be a conflict because you have no dealings with that property. That's your business, that's your line of work, right?
Okay.
Mhm,
Oh,
yeah.
okay, okay.
But
If
if,
there's a
but
difference,
if it was the
you
same property that you do,
have-
then it's a
that's
conflict.
Okay, okay.
Mhm.
Yeah. You don't have any interest in that one.
I'm so glad he understands conflict, because many people don't.
Yeah.
So trust property vests jointly in all trustees, whether the trust is created inter vivos or by will. The power to appoint is always contained within the provisions of the trust instrument, and that's what we just read here in our trustee, where the protector has the power. So unless the settlor reserves the power of appointment to himself in the trust instrument, he no longer has the power or the right to retire or remove trustees from the trust instrument. And this deed I gave you, it was given to the protector, of whom he may be.
Yes, yes,
He takes a different role.
yes.
A settlor, when he creates the trust, once a trust is created, he is either a beneficiary or he can be a protector.
And to change that, would have to go through courts.
Change what?
To change him from whichever position,
Hmm.
no?
Mm-mm.
This is the,
What's his document?
Okay,
Mm-hmm.
now if he was dead, he.
This is dead, yeah, they have to go to court.
okay.
And then I set up the section of the act that speaks to the appointment of a trustee. Section 42. A person who is nominated in the trust instrument to exercise the power of appointment of new trustees may do so, notwithstanding the fact that his beneficial interest may already be disposed. As this specific power of appointment is not conditional upon his beneficial interest. So let's just say he had an interest in the trust. And he also has the power to appoint. Because he no longer has an interest, doesn't stop him from executing his power of appointment. The person who has the power, let's just say they had an interest in the trust all along. And they no longer have an interest now. Just because they no longer have an interest doesn't stop them from exercising their power of appointment to appoint a trustee. And of course, all appointments must be in accordance with the terms of the trust. The appointment of a new trustee is normally made by deed of appointment and is executed by the parties, particularly where a new trustee has been appointed to replace a retiring trustee, or you're appointing an additional trustee for an existing trust. You have a question? Or your mind just going 100 miles an hour?
Well, you people make grading.
Don't let me read in the paper 5 years from now, Nathaniel and his trust, because I'll have to call all you all. Because he didn't invite us. So new trustees may be appointed not only by persons nominated in the trust instrument for purposes of appointing new trustees, but also by the surviving or continuing trustees or the personal representatives of the last surviving or continuing trustee by inter vivos trust only. The PR of the last surviving or continuing trustee is not required to exercise the power of appointment and may not be forced to do so. The purpose is to enable a trustee who is disclaiming or retiring to appoint his successor. The surviving trustee together or a sole trustee to retire at the same time appoint new trustees or a new trustee to act in their place or his place, which could not be done if this power was given to the continuing trustees or trustee in the prima facie sense. A consequence of the section is that an appointment of a new trustee made without the occurrence of a refusing or retiring trustee would be void. Because you just can't willy-nilly go and appoint a trustee. If the refusing or retiring trustee could show that he or she was competent and willing to act and was not consulted. So you can't just go replace the trustee because you don't like them. You have to have a valid reason. And then I gave you the case of Stoneham settlement. And then Rebrook Bank.
Now, with these are different. We can find these online,
Mhm.
so we just punch them in and they
Mhm.
automatically will come up.
But in most of them, we have given you the summary. That's all you need to know.
Okay.
Mhm. So when all the trustees of a will predeceased the testator, the last of them to die is not a surviving or continuing trustee. And so his personal representatives are not entitled to appoint a new trustee. So what this means is this: you have a will, and in the will you have an executor and a trustee. Okay? So testator dies, the executor then starts the process of probating the will. That executor trustee died before it's finished. His personal representative has to take on the will he started. That's what they call about that surviving and continuing trustee.
Okay.
If in that process, his personal representative dies, the next personal representative then has to do the two wills before that.
By law.
Are surviving and continuing. So that's why it says here, therefore the power is exercisable only to the personal representative of a trustee who was alive at the time when the trust came into effect. So it doesn't happen if the trustee, if the executive trustee died before the testator, it won't work. The executive trustee have to be living when the testator dies. And then if that trustee executor dies, then his trustee executor takes over both. So new trustees may be appointed in the place of an outgoing trustee, or like I said, to add in another trustee. If you want to replace a trustee, the law gives you the grounds on which you can do so. Death. If you stay out of the jurisdiction for 12 months, you could be replaced. That's what happened in the case of Restone Selman. He stayed out of the jurisdiction for over 12 months. And then he wanted to go to the court to say they had no right to appoint a new person. But the law states it's 12 months.
I have one question on that part. What if the trust account has assets in different time zones in different countries, and he just was in one of those where the assets is?
You don't have to be in-
Well, yeah,
Huh?
you don't have to be where the assets are.
So I mean, if because he's actually basically the asset manager, and he's
No.
managing it.
He's not the asset manager.
Let's do it.
But why would you say he's the asset manager though?
No, that's what I'm saying. It's basically like a
No,
Because
no.
He's he has to, with the trust, he's managing the asset and investing it and everything. So it's basically similar. And he do have a
He will hire an investment manager.
yes, he'll hire, but then he's still managing it.
Yes,
So I mean,
but he's not putting his hands in there.
no, yeah,
No, he doesn't do that.
yeah, I know that part, but then that's what I'm saying. So
That's why the fees are high.
yes.
He doesn't do that. So another, we can replace him where a trustee desires to be discharged. He no longer wants to carry out that role, or he refuses to act, or he is unfit, or where trustee is incapable of acting, physical or mental. A trustee who is a minor may be replaced. And by law, the total number of trustees must be 4.
By law.
By law. No more than 4. Now you can have an appointment by the court. What happened? You want more than 4?
No.
Oh, it's not a party.
Appointment by the court. Whenever you go to the court, it's always the last resort. You don't run to the court for any and everything. So it's expected that the trustee will carry out his duties according to the terms of the trust deed. Last resort is to go to the court. So the court can appoint a new trustee as a substitute for one that has died, retired, or being removed, or as an additional trustee. The court can do that. And whenever the court does it, they do it where it is expedient, difficult, or impractical without the assistance of the court. So that means the court doesn't just do it because you want it. It's to fall within a certain criteria. The court will not exercise its powers if an appointment may be made out of court by an express or statutory power. The court will also not interfere if a person has an express or statutory power to appoint new trustees, even if requested by the beneficiaries. So even the beneficiaries go to court and say they want a new or an additional trustee, the court doesn't interfere if there is an express or statutory power to do so. An express power can be in the trustee, as in this case, where it's given to the protector. So in the case of Shalaram and Shalaram, the court gave the considerations that they would go through if they had to appoint or remove a trustee. And they open it by saying that everything depends on the facts of the case. One, they look at the interests and welfare of the beneficiaries. Then they look at the actions of the trustees. And then they look at the nature of the duties to be performed by the trustees. So those are the considerations. Now, when it comes to them exercising their discretion, the court again has consideration. So the court doesn't make these decisions willy-nilly. Everything is based on law, either in the legislation or by common law. Remember, common law means case law coming from England. So in the case of Reed Tempest, it was established that in exercising its discretion in appointing a new trustee, the court will consider the following. The wishes of the settlor. Is the letter of wishes binding? No. The wishes of the settlor, the interests of all the beneficiaries, and the efficient administration of the trust. There are certain categories of persons who have traditionally been unsuitable to be appointed as trustees. A beneficiary under the trust, the attorneys of the trust, and to a beneficiary. It says in modern times, it has been accepted that there may be an advantage to appointing a beneficiary as a trustee or an attorney as a trustee. Now, to be appointed as a trustee, there are certain qualities that they look for. You must have integrity. You must be willing to spend time to deal with the trust affairs. You must get on with your co-trustees and with the beneficiaries. And you have to have good knowledge of finance, of good business acumen and common sense. Where the existing trustees refuse to act with the person proposed by the court, a balance has to be struck between upholding the court's dignity and avoiding a situation where there is friction between the trustees. Because that friction could, of course, be detrimental to the trust itself. So normally being appointed to the trust, the trustees are advised to take certain actions to ensure the preservation and protection of the trust assets. First, he has to review the trust instrument. And he's doing that so he could be sure that he is aware of all of the specific terms of the trust,
and he's knowledgeable about the provisions in the trust so that he doesn't be sued by the beneficiary for breach of trust. So if you're working in a trust company, for every trust, there's one of these. And you have to read every one, because each one is different. He should review and inspect the trust documents accompanying the trust instrument, inclusive of the trust accounts. He has to review the notices, the memoranda, the trustee minutes, and whatever other documents there are on the file. He should also confirm that the trust has been properly stamped and validated, and that the stamp duty has been paid. He also has to ensure that the trust has been properly constituted by confirming that all the legal formalities or requirements have been met to properly transfer the trust property from the settlor to the trustee. So no matter how many hands this flows through, it's the same check carried on. The same things are done. So whether the transfer of trust property requires a reconveyance of land, share, transfer of shares, change in ownership of bank accounts, the trustees must ensure, subject to the terms of the trust, that he has legal ownership and control of the trust property. So if you were added on, now let's say the three of us were trustees and you were added on as a new trustee, it is expected that you will do all of these things because you have to ensure for yourself that all the proper steps were done and that the trust is valid. So it's not just the three certainties, it's also the requirements for the transfer of the legal interest from the settlor to the trustee. All that has to be done, and you got to do it on your own. So he has legal ownership and control of trust property as soon as it is practicable. The trustee must also ensure that he invests the trust funds promptly to minimize the risk of loss. So let's just say the settlor has put in an additional $2 to $3 million. Cannot wait a week trying to figure out, should I invest it in this? Should I invest it in that? Because it may not be the beneficiaries now, it could be their children 10 to 15 years from now, when they look at the assets of the trust and returns that they're getting, and they ask for proper accounting, and they realize that there was a delay, that they could bring an action for breach of trust because you caused them to lose money. So that's why you have to know what you're doing. The trustee must ensure that he invests the trust property promptly to minimize the risk of loss to the trust and potential breach of trust, so the beneficiaries will sue. He also have to inspect the trust to ensure that there were no previous breaches by the other trustees, the earlier trustees, because it could also make him liable as a new trustee. So even though an indemnity would have been signed, it may not go far enough to protect him, because it is known that once you are appointed, it is upon you to check all the documents. So he can't say he didn't know. Now, when a trustee retires, he can do it in 4 ways. He can retire by an express clause in the trust instrument, or he can retire under Section 46 of the Act, which is a discharge, or he can ask all of the beneficiaries to release him. And of course, they have to all be sui juris and absolutely entitled to the property. And the 4th way is, of course, as a last resort, you go to the court. Now, if you want to retire and you're not replacing anybody, so there's 4, 1 is retiring, so you still have 3. A trustee may retire without replacement where at least 2 individuals or a trust company remain to administer the trust. The remaining trustees and any other person empowered to appoint new trustees consent by deed to the retirement, the trustees execute a deed of retirement. She falling asleep or she do go? Yes. A purported retirement which does not comply with the statutory provision is invalid. The court may discharge a person under section 48 of the Act only where it is willing to replace the trustee with the power given by the section. The court has an inherent power to discharge a trustee without a replacement in an action to administer the trust. And this may occur where the trustee is not able to retire under the section, or the trustee cannot obtain the requisite consent from the beneficiaries. Now, of course, a trustee can be removed where he is outside of the jurisdiction for more than 12 months or more. Or he can be removed if he refuses the act, or if he is unfit, or he is incapable of acting. And as a last resort, the court can remove him. So the court has an inherent power to remove a trustee without replacement under the principle in the case of Letterstad versus Brothers, which is that a trustee may be removed if his continuance in office would be prejudicial to the due performance of the trust and also to the interests of the beneficiaries. Fraud, bankruptcy, gross incompetence would be grounds for removal. But it's not necessary for those seeking the trustee's removal to show misconduct on the part of the trustee. It's only sufficient if there is a friction between the trustees or the beneficiaries or lack of confidence in the trustee. Then I give you the case of the Makata versus City Trust, where under the provisions of the trust deed, the corporate trustees had power to terminate the trust and pay the capital over to the income beneficiaries in equal shares. The income beneficiaries requested such termination by letter to the trustee, setting out detailed reasons for the request. The trustee rejected the request in a perfunctory manner and after undue delay. The beneficiaries sought the removal of the trustee by the court on the ground that the relationship between the trustee and the beneficiaries was unsatisfactory, and that such removal was in the interest of the beneficiaries. Justice Georges said the principle to be applied in considering the removal of a trustee were discussed in the case of Letterstad versus Brothers, and their lordship stated, in exercising so delicate a jurisdiction as that of removing trustees, their lordships do not venture to lay down any general rule beyond the very broad principle that their main guide must be welfare of the beneficiaries. Always it has to be the welfare of the beneficiaries. Probably it is not possible to lay down any more definite rule in a matter so essentially dependent on details often of great nicety. Earlier, their lordships had discussed the dearth of authority in this area and had agreed that in practice, once issues of character had been settled, once it was clear that the continuance of the trustee would be detrimental to the interests of the trust, even if for no other reason than the human infirmity would prevent those beneficially interested from working in harmony with the trustee. The trustee is usually advised by the council to resign unless the trust instrument indicated a contrary intention on the part of the settler. In this case, there were veiled allegation of breach of trust and rather direct charge of incompetence. Understandably, these had to be resisted, and I find that they have been disproved. I do find, however, that the charge of unresponsiveness has been made out, and I am satisfied that the relationship between the income beneficiaries and the trustee is such that the interests of the beneficiaries are likely to be affected. The income beneficiaries are both form the record competent and experienced at managing large assets and the trust is likely to benefit from close collaboration between themselves and a trustee in whom they have full confidence. The trust instrument makes clear that the interests of the income beneficiaries are to be the primary concern of the trustees. Paragraph C of the 5th article reads, the power vested in the trustee under the foregoing provisions of this article shall be exercised with primary regard for the interests of the income beneficiary of the particular trust, or to the extent the trustee shall deem appropriate, the interests of the members of her family and the interests of any other person shall be disregarded. So you see, the trustee was between a rock and a hard place, because the deed itself states that he had, whatever he did had to be in the interest of the income beneficiaries who had knowledge of what he was doing. So in the circumstances, although I find that the allegation of incompetence and possible breach of trust have not been substantiated, I am satisfied that in the interest of the welfare of the beneficiaries, there should be a change. And then a more restrictive approach to removing a trustee was decided in the Bahamian case of Viso versus Chase Manhattan Corporation Limited.
They don't about it.
No. No, they left. Chase was big in those days. Yeah, they left. So you see, even though they didn't have the proper grounds to have the trustee removed, this provision in their trust deed was to their advantage. If this wasn't in here, then a different decision may have been made, meaning that the trustee would have to stay.
Yeah.
But because this provision was in here, that gave the court more reason to go in their favor rather than the trustee. Everybody happy now?
That's the code.
I want to know why Ashay looking like she's frozen.
Cold. Cold.
All right, so
Was it, your portion was the biggest portion, so, I mean, it's just, these are the pressure on it.
what do you mean?
Listen,
What do you mean pressure? I don't understand. Have I put pressure on you?
my friend, you all have a lot to know, and you have a lot of information. Right? Totally, Mr.
That's half the book. She didn't into half the book.
Fine.
She
If
didn't-
you're concerned, hopefully you just agree, just come in, say in 1, 2, and that's it.
You let me know. Let me know when you come to do your review.
I don't look for that, so probably like that.
Okay, so you think it'll be a breeze? Right? Mhm,
What do
see?
you think would be a great fit? Or, okay, good stuff.
I'll put some question. You do it now. Do it. Bring it on the day of our review,
Okay,
but I want you to answer it without looking in the book.
okay.
Don't answer it by looking in the book. That's cheating.
Just, you know, okay.
What? What is? No. Yeah, Andrea, you hear that? She asked me if it's an open book.
Boy, that would be like the best Christmas gift ever.
Thank God I don't distribute them.
Yeah. Yeah. Get you ready on some questions for us in the back.
Which ones? Mean at the end? Or they only just to see if you understand the book?
Boy, when I look at those questions, I realize I probably really don't understand the book.
Yeah, right. There you go. The question is, the appointment of trustees may be made in several circumstances. Discuss these circumstances. Who can appoint a trustee and a trustee's power of discretion? That's only one question.
I know. I see loaded.
We're done. We're done.
Oh, okay. Oh, I just need this link, that's why.
Oh, yeah, we're done.
All right, thanks.
You got that, Deandra?
Who can appoint the trustee
Deandra?
and trustees power?
Hey, I got the first line on my circumstances.
Okay, because they need the link. Discuss these circumstances,
Uh-huh.
comma, who can appoint a trustee and a trustee's power of discretion.
And a trustee
Power of
power.
discretion.
Okay.
Mhm.
You said this is due the week of review, right?
Yes. And I want you to answer it without looking at the book.
Okay.
All right? So everybody have a great weekend.
Oh, you done rubbed that off my face.
What you mean everybody didn't write this?
I write it.
Have a great weekend, Deandra.
Okay, to Miss
All right.
Archer. So I'll email you on that week to remind you,
Okay, yes.
and we'll see you soon.
Bye.
Bye.
Okay.
Bye-bye.